that?
Yes, sir.
All right. And based on that, you personally have decided that you wish to waive your right to a jury trial?
Yes, sir.
Do you need any additional time to think about that decision?
Honestly, no, I think I've had enough time to sit and think about this whole dilemma of this case and everything else that's been transpired over the last couple of years. I'm honestly just ready to just get it over with and continue on with my life.
And I can understand that, Mr. Johnson. I mean, we've had to kick this case along for a long time. I understand it's a reindictment of an 18 SC case. You've been living with this for 6 or 8 years, I think it is. But it's all finally come due this week. We're going to have a decision one way or another on this case. And like I mentioned, there are pros and cons, and especially with charges like this, there are some things a jury um, could hear, and I'll tell you, if it's a bench trial, that's going to be something where the charges themselves aren't going to be driving the decision that I have to make. I'm going to be focusing solely on the evidence that's presented. So, do you want to, as much as you can, as much as you're willing to, is there anything driving your decision of why you would like to waive a bench trial in this case, or waive a jury trial?
There's nothing here. There's nothing here. It's literally been dragging on for no reason. There's literally nothing against me. I've literally have followed every rule and regulation that has been given to me. I've stayed out of trouble. I kept my head low. I'm, I'm like I say, I'm just ready to honestly get it over with because by this point on my side, there's nothing for us to prove. It's literally somebody saying something against me that needs to prove that I've done something. So I feel like I'm doing my part as a citizen and as a human being by staying out of trouble and staying out of Harris' way. I don't know if there's anything else that I can do by this point.
Okay, I understand what you're saying there, and is there something about, do you think a bench trial is going to be a better idea for you rather than a jury trial based on what you said?
Mm, Honestly, I feel like it don't need to go that far because of, like I say, this would have, personally, I feel like this would have been over a long time ago. Because,
All right, I understand. And the last thing I want to make clear is that this is the moment you got to make that call, because tomorrow or later today, if you hear some of these witnesses, the state's going to put up, we can't change our mind and unwind that. Once we make that call, we're moving forward. You understand that?
yes, sir.
All right. Okay, Ms. McCauley, do you think there needs to be anything put on the record as it relates to this decision from Mr. Johnson?
No, Your Honor, and no objection from the state to proceed with a bench trial.
All right, well then, both parties having placed it on the record, I really don't see any equivocation or wavering on the part of Mr. Johnson. It seems like he's in consultation with counsel, made this determination and decided that this is how he would like to proceed. And that's your right to do that as well, as to waive a jury trial. So with that, we'll proceed. And just to kind of give the lay of the land, as my understanding, and a bench trial we did last summer, I think we went through the process of maybe even talking about a charge conference, something like that. I don't think we actually needed to do that. So when it comes to just logistically, I want to confirm what to expect, which is obviously we don't have to worry about voir dire or impaneling the jury, but we'll just proceed with the state's witnesses, and at the close of the case, then we'll come back, and I guess I'll go ahead and type it up as a verdict form as well, like we did before, even though I also don't think that's technically necessary. But is there anything else we should know logistically about how we need to proceed the next couple of days? Are there any witness scheduling issues, or,
Yes. Yes, Your Honor, the state does have some scheduling issues I would like to put on the record. So we have three witnesses, well, actually two witnesses that had travel arranged. No, I'm sorry, there's three witnesses that had travel issues, based actually on the outage from Friday. So the first is Monet Patrick. She's flying out of Houston. She has been scheduled for a flight this evening, but she will not be available until tomorrow morning. The state is intending to call her last. So probably would not be an issue for starting evidence today, but we may, because of the other two witnesses, may cause a little bit of a disruption to today's schedule if we might have to adjourn early. The next witness is Dr. Tricia Sheridan. She is the second to last witness, and she is coming in from Florida. She will also be here tomorrow morning, but we could not get her here any earlier than tomorrow morning. And then the last witness is Nikki Porter or Nikia Porter. Ms. Porter is in a remote area in Oregon. She's 190 miles from Portland, Oregon. The state was not able to reschedule her flight to get her here for trial. I did ask defense counsel if he would consent to having her appear via Zoom, if that would be amenable to the court. And obviously, if defense counsel objects to having Ms. Porter testify on Zoom, the state will just forego her witness testimony.
Well, by the way, you wouldn't happen to have a witness list for me, would you?
I do actually have a witness list
Okay.
for you.
And on that point, Mr. Marks, do you need more time to discuss and consider this ability for this witness to testify remotely? Should we come back to you on this issue, Mr. Marks, about the remote testimony?
Oh, I was just talking to my client.
Yeah.
I didn't talk anymore.
Oh,
You can have more time to think through that. I know this is a recent.
I talked to my
Request.
client and
You get
and
both
we're
of them.
okay
There's
with
multiple witnesses.
the testimony by Zoom when it comes to that particular witness. Nikki Porter, is that her name?
yes.
Okay.
Okay. So tentatively, and we can revisit this issue and confirm again
Sure.
once we have a better idea of the lineup. But I'll just say this, when there's not a jury in the box and there's no concern that this case is going to spill into next week, if we end early for the day, that's perfectly fine with me. It's more so I'm trying to be efficient with the jury's time and respect the sacrifice the jury is making, taking this out of their lives. So if we don't have any further witnesses to present and it's 3:00, that's fine. I don't think we should be punishing efficiency. And so, Ms. McCauley, to that end, don't feel like you have to drag things out or that there's any problem with ending early for the day. I think it seems from the representation of counsel, we're going to get through this by Wednesday at the latest. So, noted. Thank you for that heads up, Ms. McCauley. Anything else in terms of logistics or scheduling we need to worry about? Again, generally, we're going to have an extra days of work as we break for an hour for lunch. And then unless anyone here needs a break, we'll just, until y'all tell me you need to take a break in the morning or afternoon sessions, we'll just keep moving forward.
Okay.
Judge, I guess what we can do is commence with maybe a brief opening and then the state can start introducing their witnesses.
We'll do that. Again, a few little housekeeping things I just wanted to go over. So in order, we had state's motion for a ruling on in-camera inspection of some DFAX records. Through email, it appeared the defense counsel was not intending to introduce any of those records. So I would, in essence, grant the state's motion or deny it as moot, whichever way it goes. It just looks like it's not really an issue that needs a ruling on at this point, or does it, Ms. McCauley?
So, Your Honor, it would need ruling on because the state is going to seek to introduce some of those records, but they're limited to this incident and they've been limited in terms of their, I guess, value as an exhibit, does not disclose anything else going on that's indicated in the records. So we would just want to make sure that the testimony is limited to only those exhibits and only that testimony. The state is not intending to elicit from Dr. Wallace, and I believe that that's the witness, that there was some additional diagnosis that resulted from this incident that would need to be explored as like an alternative source of injury, I guess, theory.
All right. Without really knowing the facts of the case, it's hard for me to kind of process what you're saying. What I would say logistically, have you been able to show defense counsel the records that you intended to introduce?
I have indicated on the state's exhibit list which notes I'm going to use. I actually received the records from defense counsel
Okay.
because they were never provided to the state by the court.
Well, let's just make it clear for the record, this was in the
Not by
court
this
in
court, not by
2020.
this court, yes.
All right. Because what I was going to say is Mr. Marks able, unless he knows exactly which records, is he able to articulate a response at this time, or you need more time?
No, I can articulate a response. We don't intend to introduce the records. Under the rule of completeness rule, we do have a right to have them all come in if some of it comes in, but I don't think I'm going to do that. Our position is that the records are not material to our defense anyway, so I don't intend to object to the introduction of those records or seek to introduce additional records.
And it's not so much only the records themselves as maybe there are other issues inside those records that you may feel open up avenues of cross-examination. I think that may be also something we need to figure out here.
Yeah, that's true. Now, I've reviewed all of the records and I think that's unlikely. But if a door is open and I need to explore that by cross-examination, I understand I have the liberty to do so, but I don't think that's going to be the case. But I do have the records. So if I need to access those records and ask a question on cross-examination with reference to those records, I do have them. I'm familiar with them and I've read them.
Okay. All right. Then so I think just for clarity's sake and for the record, we'll say that before defense counsel is to begin cross-examination of any witness, if there's some portion of those records or the subject matter contained within that you want to elicit, I'd ask that you bring that up before cross-examination. We'll be able to excuse the witness. We can talk about it and make a more definite ruling at that point. And so for now, I think the state's motion then for a file July 15th on the confidential records would be granted in saying that they, without objection from the defense, that at this point that there would not be admissible, and we can revisit that at any time upon motion of the defense. Anything else we would need to address on that?
Nothing on that issue, Your Honor.
Okay, moving along, we had Mr. Marks had filed a motion in limine to exclude cumulative testimony, and I'll just go ahead and say on that, I agree in principle that under rules 403 and 611, the trial court always does have the discretion, if need be, to step in and make those kind of determinations if testimony is becoming cumulative, it's not adding anything. But on the front end here, I don't think I'm really inclined to wade into that, and we'll just see where the trial takes us if that becomes necessary. So, Mr. Marks, I'll say you can re-raise it at some point if you feel the need to, but generally, I think the state's going to be allowed to introduce corroboration in a case like this.
I totally agree. I believe the state, under the Child Hearsay Act, these witnesses have testimony that is probative and it doesn't contravene the confrontation clause or hearsay because of the statute. However, the trial court still has the authority to exercise its discretion and exclude any evidence that it deems to be cumulative. And I would guess that maybe after a few witnesses, if it's just the same thing, especially if the defense is willing to stipulate that the next 7 witnesses are going to say essentially the same thing, then we can address that then.
Well, we'll see where we are at that point and how the issues narrow if they do. All right. And so, again, denied at the moment, but you can re-raise it at the point if you feel it's necessary. We also have a defense motion in limine asking to exclude testimony concerning defendant's conduct with another minor. It looks like under 403 and 404. So anything there you want to add, Mr. Marks?
Sure, Judge. And the law is clear when it comes to bench trials that the presumption that the trial court will only consider admissible evidence. And our contention is that evidence is not admissible because it's the statement of the complainant concerning what the defendant communicated to the complainant about activity between the defendant and a third party. So the state hasn't filed any 413 motion or anything like that to introduce evidence of the defendant in relation to a third party. And because of that, we would contend that evidence is inadmissible and should not be considered.
Okay, Ms. McCauley, is this something that should even, we go down that road and
Yes,
need
Your
a
Honor.
direct testimony?
Yes, Your Honor. The state does have a response prepared to defense counsel's motion. So in defendant's pleading, he stated that he sought to exclude the statement, and it's this child's statement in the forensic interview that the defendant had told her that he had engaged in sex acts with another 15-year-old. The interviewer does explore it with the child, and she doesn't have any identifying information. It is merely a statement that the defendant made to her. While it is generally true that a defendant's character cannot be put in issue unless the defendant elects to put his character in issue, material evidence does not become inadmissible simply because it incidentally places the defendant's character in issue. And that citation, Your Honor, is Johnson v. State, 268, Georgia Court of Appeals, 1, pinpoint at 6.
You're calling this intrinsic evidence?
Yeah, it's
Okay.
intrinsic, Your Honor, but it's also material in explaining the conduct of the child. And that is relevant as the forensic interviewer would testify that that statement was in fact an act of grooming by the defendant to remove the child's inhibitions to get her to be more comfortable with the sex acts that were being performed. Even certain comments in forensic interviews become admissible, even if it puts the defendant's character at issue. That's Anderson v. State, 282, Georgia Court of Appeals, 58, pinpoint 63 to 64. Grooming is very much a widely accepted area of expert testimony. It's widely accepted both as expert testimony individually as well as coupled with the forensic interviewer. It is not evidence of 413. If the state were seeking to use it as evidence of 413, 414, or 404B, the state would have to provide additional information. Because this is a statement of the child saying, this is what he told me. It's not only intrinsic, but it also doesn't rise to the level of 414, 413, and 404B evidence. So on that basis, Your Honor, we would ask that the statement remain in, and also acknowledging that the court, in conducting a bench trial, does have the responsibility to sift through evidence both deemed admissible and inadmissible in serving as the finder of fact.
All right. And so this is the sole issue here is it's during the forensic interview or maybe during the, alleged victim's testimony itself, but it's just this one line where allegedly Mr. Johnson tells her that something like this had been done before with another 15-year-old and that's it.
That's correct.
Okay. And so if deemed intrinsic, I think we would still have to discuss 403. And so anything you want to add of why this isn't unfair prejudice and that maybe give me a little bit more about why this isn't substantially outweighed by its probative value.
Well, when we're talking about engaging in sex acts with a 15-year-old and the dynamic between, just to give the court a little bit of context that might assist in the 403 analysis, when we're talking about whether or not it's more probative than prejudicial, it's put in the context of the sex acts with the child, the relationship the defendant had with the child. In this instance, he is her tumbling coach. He is trying to gain her trust through a number of different mechanisms, through both his coaching in the gym, his relationships with the adults around her, and then ongoing communication that was happening with the child outside of the gym via Snapchat. In communicating with the child, the conversations become explicit. They become very explicit. They discuss specific sex acts that they would like to perform on each other, what she is willing to do and what she is not willing to do. Those conversations ultimately lead as a basis to count 1, but also the acts that are ultimately performed in counts 2 and 3. In connecting with the child and gaining that child's trust, both a forensic interviewer will testify as well as the victim that statement to her of, hey, I've done this with other girls your age or another 15-year-old is relevant and probative for exploring the grooming process that was going on with the child and whether or not the defendant was gaining the child's trust. That is incredibly relevant and incredibly probative in order to get this child to engage in these sex acts with the defendant. So on that basis, Your Honor, if that would assist with the 403 analysis, the evidence itself is more probative than it is prejudicial.
All right, Mr. Marks, I'll give you the last word since it's your motion.
Thank you, Nate. Please, the court. The defense contends, which is set forth in the motion, that this evidence is substantially more prejudicial than probative and should be excluded on that ground. And in addition, constitutes character evidence of the accused and should be excluded on that additional ground. So that's the defense's petition, and I just want the record to reflect that.
All right, understood, Mr. Marks. So based on the representations and proffer of the state, I do think it would pass the bar as intrinsic evidence, as I think the state's theory, as I understand it, is not necessarily that Mr. Johnson did actually commit some other act with a 15-year-old. That would be the form of a 413, or that there was a prior act, but at a minimum, the theory here is that he's using this as outlined by the state as a way of, as they put it, grooming, and that's their theory. And so under that logical theory, then I don't think that would be unfair prejudice that substantially outweighs its probative value. And regardless of how it comes out, That's not going to be something that I'm ever going to hear and just consider solely as character evidence that because Mr. Johnson may have said this, that makes him a bad person, that he obviously did this one. That's not going to be something that I ever consider it for. It's just going to be under the state's theory of why it's relevant. So I would deny defendant's motion to limit to exclude testimony. That then takes us to notice of request for dismissal.
Yes, Judge. We are formally requesting the state to dismiss all charges against my client at this time by entering a null pros. And I want the record to reflect that too. If the state's not willing to do that, unrelated matter, we are stipulating that the foundational requirements when it comes to the jail calls as well as the CD containing the forensic interview have been established.
All right, so that's not something the court really has any power over at this phase, just sua sponte dismissing things. There has to be certain things that happen before a court can do that. So that's solely in the state's purview right now. So, Ms. McCauley, any reactions to this motion?
No, Your Honor, the state just has a couple very brief oral motions to make before we start trial.
Okay, but in response to Mr. Marks, are you taking him up on his request for a dismissal?
The state will not be dismissing.
All right. One thing I want to do before I forget then is, well, we'll let you go ahead, Ms. McCauley. What have you got?
Yes, Your Honor. So there is some evidence in the forensic interview. I believe the timestamp is 30 minutes and 12 seconds. When the interviewer asked the child about whether or not she's engaged in these types of sex acts with anyone else. It's a very common question during a forensic interview to explore alternative hypotheses. However, the child then answers that she has had consensual relationships with boys her own age. This evidence falls squarely under Rule 412, which is the rape shield motion, which is the rape shield statute, rather. The statute requires that if either party seeks to introduce that evidence, they must file a motion at least 72 hours before the trial date and be subject to an in-camera proffer with the trial court. Neither party has moved to introduce that evidence, and the requirement is both on the state and the defense. So the state would request that evidence be deemed inadmissible. Obviously, the court in conducting a bench trial can sift through what it deems inadmissible or admissible. And in this context, the state does not have a problem playing the full forensic interview as long as it is clear that any of those statements do not come in and should not be considered by the court as the finder of fact, nor should they be utilized as argument or utilized as improper character evidence against the victim. The victim should not be subject to cross-examination about any of those statements, nor should the forensic interviewer.
Mr. Marks.
Your Honor, that evidence is not germane to my defense, so I don't object.
All right, so without objection, state's motion based on rape shield would be granted. This is in reference to any questions asked during the forensic to other conduct or relationships by the alleged victim. Anything else, Ms. McCauley?
Yes, Your Honor, there's just one other request of the state. I noted that the trial is being live streamed. The state assumes that is being live streamed on the internet. For the purposes of the victim's testimony, the state would request that, and I believe it's pursuant to 17-854, but I might have that confused with 17-855, that due to the nature of the testimony of the victim and the fact that she was a minor when these incidents occurred, that her testimony not be live streamed, nor would the playing of the forensic interview be live streamed.
Mr. Marks, any thoughts or positions on that?
We don't object. We don't really care whether this is live streamed or not. I mean, our preference would be that none of this is live streamed, but I understand that the rules of the court is that these things are live streamed. So I don't object to that motion.
So with that, with the live streaming on YouTube, that's something I've just generally done for motion hearings, for trials. I found that, it sends a good message of transparency and of open courtrooms. And it also can be helpful when I need to go back and review things and just double check what actually did occur if I need to rehear something. Probably in the bench trial context, not the way I'll use that, but without if there's not an objection from the defense to essentially removing that. That's why I put in the case management order that upon request, we can take that down. So I don't see a need then to do that. So I'll grant the state's request for alleged victim's testimony. You just need to give us a heads up when she's heading this way, and for the forensic interview publishing. Anything else, Mr. Colley?
Nothing else from the state, Your Honor.
All right. So as with any trial, what I try to do at the outset as well is make sure we've made a record of any plea negotiations, of any offers that remained outstanding, just for the purpose, I'll tell you, Mr. Johnson, it's not because I think you ought to take the deal or that I think you should. It's more, we just want to make sure that you have been informed of if there was any offer, and again, whether it was your decision to decline that. It's completely your call. I just want to make sure that it's on the record if there was one and if it is expired and that sort of thing. So, Ms. McCauley, if you could run through counts 1 through 5, what the range of punishment would be if convicted, if there's a mandatory minimum, whether it's parole eligible, and then the state's best and final offer on this case, and if there's an expiration date.
Yes, Your Honor. Just checking one issue. Okay, as to count 1, enticing a child for indecent purposes, the mandatory minimum is 10 years, the maximum is 30 years. That is a parolable charge. Count 2, aggravated child molestation, the mandatory minimum is 25 years, the maximum penalty is life without the possibility of parole. That 25 years is a non-parolable charge, a non-parolable 25 years. As to count 3, aggravated child molestation, the mandatory minimum is 25 years. The maximum is life without the possibility of parole. That 25 years to life without the possibility of parole is not parolable. Count 4, child molestation, the mandatory minimum is 5 years. The maximum is 20. There has to be at least 1 year of probation for count 4 and count 5. That is a parolable offense. And count 5 is child molestation, mandatory minimum of 5 years, maximum of 20, with at least 1 year of probation. And that is a parolable charge. All 3 of these counts require registry as a sex offender. As a sex offender, counts 1, 3, and 5 are subject to the sentencing restrictions set forth in 1710-6.2. Count 2 and 3 are subject to the sentencing restrictions set forth in 1710-6.1. The last offer that was made by the state was a 20 to serve 15 as to the offense of child molestation. There was an expiration. The expiration was the date of final plea. There were continuing conversations between myself and Mr. Marks. Mr. Marks, on Mr. Johnson's behalf, did make a counter offer of a non-registry offense with probation, to which the state rejected.
Do you know where child molestation falls on the parole grid? Is that a 66%?
So enticing and child molestation both fall into the 65 to 90% range.
All right. So, Mr. Marks, was that the offer that was conveyed to you, and was that the best offer the state ever made on this case?
Yes, Your Honor, that's correct. The only thing I would add is the that sentencing range is something that the Department of Corrections can depart from. It's just a guideline. They're not required. They can say, no, we're never going to parole the defendant out, or they could depart from those guidelines and parole the defendant out the very next day. They have that discretion. So those guidelines are basically
Okay.
guidelines.
All right. And so that offer was conveyed to Mr. Johnson, and he declined that offer. All right. So since that time, I did see that the state had filed a bench brief, pretty much kind of comprehensively laying out the law that applies to these kind of cases and some of the issues there. I don't know what Mr. Johnson's position is in terms of what happened here. He doesn't have to present any defense whatsoever. It's not his burden of proof, and he feels quite confident that nothing happened here that was criminal. I'm wondering, Mr. Marks, if you've had a chance to perhaps review this bench brief with him, because maybe some of the issues that he believes apply in this case are impacted by the law as it's outlined here. And as I read this bench brief, it does appear to be an accurate and comprehensive statement of the law. And especially with some of these sex offenses, the issues of consent and that sort of thing, there's not a lot of leeway there, and there's not a lot of wiggle room. And so I just want to make absolutely clear, Mr. Johnson understands some of the defenses he thinks he might want to pursue that aren't actually defenses under Georgia law.
Right, yes, and Your Honor, I've discussed this with my client. We're not arguing, our defense isn't that this was consensual. Our defense is that this never happened.
Okay.
And the state can't prove otherwise. So that's our defense, not that, well, he's not guilty because it was consensual. Our defense is that he's not guilty because they never had any inappropriate contact and the state can't prove otherwise.
Got it. Okay. I think that clears up a lot of concerns on my end. And all right, so we've confirmed it with counsel that it was conveyed, and Mr. Johnson, I'll convey it with you as well. That was the offer that you rejected, you were not interested in. Is that right?
From what I was told and understand, no, I'm not agreeing to their offer.
That's right. Even if it was open today, not interested.
No, I'm not off.
All right, understood. Anything else in terms of pretrial housekeeping or motions limiting we need to take up with from the state?
Nothing from the state, Your Honor.
Okay, Mr. Marks?
Nothing, Judge. I would just ask for like a 3-minute comfort break before we start with first witness.
Yeah.
You'd also mentioned wanting to kind of give me an outline of the case and an opening in effect. Do you want to do that after a break?
No, we can do that now.
You want to do that now? Okay, Ms. McCauley, any preference there?
Fine, Judge.
Again, this is going to be a very different kind of thing. I'm going to be going at y'all's directions in terms of pace because it's just me.
But if Ms. McCauley wants to take a comfort break now, I'm fine with that.
I would just prefer that we just start with the openings and then go straight into witness testimony. I just want to confirm that my witness is here.
Okay, let's do that.
Okay.
Y'all let me know when you're ready to proceed.
Thank you, Judge.
We're in recess off the record.
Thank you, Judge. Okay. For whatever reason, I cannot get my remarkable. Okay, now we're going. Now we're working. I needed my remarkable to load.
I just showed me emotions, right? I'm trying not to cry. I'm not trying not to be frustrated and mad. It's just a lot.
That's entirely fair. You know,
I'm just,
sometimes getting it out, something you just want to like write journal to yourself.
it's just, I don't think there's really much for me to say. Like, you could,
Yeah, I mean, it's just for like,
Oh,
as
yeah,
the
yeah,
day goes on.
yeah.
and everything. I'm not saying it right now.
yeah, I know. I'm just kind of waiting, just, I don't know, just trying to make sure I use my right words and stuff like that. I just, that's one thing, like walking around normally every day and then coming back.
Just a reminder,
Everything is for me right now.
the mics are still on. The mics are still on, hot. It's not from that, it's from the podium.
Okay.
So if y'all need to step out, have conversations.
But thank you for.
It still picks up at the podium. Yeah, and there's a conference room right outside. You don't pull this on. And he called out. He said, he was asking about, you know, somebody had to drop off some books. He said, well, let me go, I have to listen. He is so nosy too, like a. Mr. Morris, don't forget you all have that conference room out there too, if you all need it.
Okay, thanks. Yeah, okay. Did you want to talk to me?
And he's not, he's about his size.
Okay, that's
Yeah. He weigh about 250. Yeah, he's not a little bad. He's a big kid. Yeah. He looks like a kid too.
Like baby face.
Yeah.
Yeah.
Doesn't happen.
It's fine. So it's fine. They feel like chip over him. Yeah, he's been with Michigan. He's been here. This might be his third week here in North. How was in Michigan?
So you don't need this for
I
Friday.
heard it. That's what, that's why it's fun.
You don't need that for Friday.
Yeah, he's a good kid. Yeah. He was fine.
Did you enjoy the game?
Yeah, he did.
It did, okay.
All 9 innings.
Yeah. Yeah, we kind of.
Can't make it past
We got something. It's like, man, it's.
Do they? Do you feel like going home? Oh, because of it.
No
It's
game.
hard.
What's the game?
You
Yeah.
gotta walk that fast.
Yeah.
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 Yeah, because I can't sit past the front. I'm like, look at it.
It's different now.
We moved about the, out of the sun.
Good. How's your meeting go?
Doing great.
Great. Did she like yours? Did you do a presentation?
Yes, I did.
Did she like it?
She liked it.
Mhm. Was she like,
I don't think
oh?
everybody was good. They're not doing it.
I'm not learning that.
Good, good.
And when Janine comes back, we'll just ask him if he can, Janine can sit with us at the table,
Okay. You got brain.
if there's room.
What are the numbers for?
Oh, 911 call is 8 and 9. Miss Cad, it's already loaded in the PowerPoint. The 911 call, I have a
And then I know he had a map.
speaker for.
That was something.
I have all the photos. So these are all for Michaela. Listen, I am,
The one,
I can do this.
you are the one.
These are for Marcia. And you know, like, it's pursuant to an 803 notification,
Mhm.
803 notice.
Right, so you don't have to tender.
Right.
those.
Right, and you
There,
just
yeah.
play the 911 call at the end of Marcia's. And then you put up the CAD for when Jimmy comes in. Okay?
Yes. You know, we're live and the mics are still live.
Okay.
Okay.
Did I say anything inappropriate? Okay,
Let's just be.
okay.
How you doing, Ms. Gordon? Wonderful.
Oh, thank you.
No, we're outside, of course.
We appreciate it.
Thank you.
But that's just an FYI.
I appreciate it.
And look, me and Board were laughing at you
Why?
because, you know, we're the behind the scenes.
Mhm.
So we saw you looking.
I don't want them looking at my
I
face
know.
because I make faces.
It's a pretty one.
Oh, thank you. I don't know who this is. I think this is Stuart Webb. Hey, Stuart. Good, how are you? What's up? Private?
Sorry. Young people, I'm so sorry.
Working. Nice to meet you.
Yeah.
Where's?
She's gonna be right there.
There.
So if you sit on this side,
Okay.
you'll be fine. You can sit where my intern, or where the intern is, right there? Yeah, right there.
It's all right.
That's
Good
okay.
to meet
I was talking quietly.
You're okay.
In part of the game, they had old games feedback out. I saw like, oh, shit. But I told him, you go in the game, like, they have to go. Those things.
You wanna send, you wanna try to have this just live on YouTube? On Judge Matthew's YouTube? No, hers has right,
Yeah.
but the rest of the testimony would be, so if he wants to watch it, he can.
I think he wants to come over. She's done. Like, I think he just listens. Yeah. So I just told him I would keep him updated when she's done. And he'll probably come because he doesn't, I don't think he'll work. She was like,
Oh.
she's
Just gonna take me. Be careful.
you will. So now you can cross.
Yeah. I told you.
Okay, I'm going.
Cause in the last night,
Yeah, it was.
Don't warn her. Don't
No,
warn her.
not Kayla, I'm telling her, so she knows, because she can't come in, so like if she wants to go grab food or something, just so she knows she can do that.
Okay. Thank you, Morgan.
Yeah.
Right, so she's in the line. Yeah. Yeah.
Okay.
No, it's in.
Thank you.
Oh, Madam Court Reporter. So for the exhibits, how many USBs do I need to bring you? You need two.
And I just need the media exhibit, like the perimeter thing,
Okay.
anything that's like, has a video.
Okay, video or audio?
Yeah, you don't have to put all of it, just the. Video.
Okay, okay, I can do that.
The physical ones I can copy.
Okay, okay. Yep, absolutely.
You have extra witnesses?
I can email it to you. Would that be okay?
Yeah, that's fine.
Oh, sorry, print, is this all of them?
I can send the email.
This is-
I'll forward the email.
This is not right. This is not, no.
Can you print it for me?
Sure.
Thank you. She's gonna print it for me.
Okay, thank you.
Cause I kinda like that when I get on the quick
Yeah.
second, but check.
Those aren't right.
Please don't go out.
Mm-mm. So I don't ask other people to do my stuff for me.
No, I uploaded a P drive.
It's all under attorney work product.
So,
Yeah. It's okay. I'm used to having everything electronics. I think I like that better.
yeah, I like.
I know.
Evidence is nothing that I have to get.
No,
Okay,
it's all photos and stuff.
I'm used to getting like the guns and bullets.
Oh.
No, there's no guns or anything.
Yeah, I
That's fine.
know.
Oh, 'cause it's not on the Wi-Fi, that's why. Let me plug this in.
Yeah. They're 30 months. I give you, have anything to do.
Thanks for sharing. Have you checked out on site share?
No, I didn't.
So.
No, I have. The transport. Try. So I have been planning coming this weekend on. I'm not keeping it close. No. Like, did you have to bring that? Did you bring home? I didn't think that. Oh. No, I was just. But I told you, kind of, based on the features that I had. Yeah, based on the pictures. Like, how did I just let them bring it up? I have the pictures. So that's what I'm doing to make sure. Because I don't want to. You have to backtrack. From that. This so I check to make sure. Yeah. Yeah. And I'm that I need to work on it. So that's what I'm doing. And in order for me to do that. That's what I was worried about. So I'm sorry.
Court calls order, remain seated.
Everyone had enough time?
Yes, Judge.
Okay, let's go back on the record then. State have anything they want to introduce or remarks they want to make
Yes.
by way of
Your Honor.
opening?
Yes, Your Honor. Yeah, just 1 moment.
Oh, I get a PowerPoint. All right.
Am now. Okay. Okay. So, Your Honor, prepared a PowerPoint. This will just for purposes of whether or not this was going to be a bench trial or a jury trial, but I will proceed.
And I'm sorry to interrupt you, Deputy Scott, if we could angle this towards me. Thank you. Ms. McCauley.
Sure. All right, Your Honor, this is the state of Georgia versus Deron Johnson. It's indictment 22 SC 182609. Just to give the court a brief summary of the facts. This case arises out of the grooming and sexual abuse of 15-year-old Michaela Ward by her tumbling coach who was the defendant. In the spring of 2017, Michaela had just finished her freshman year at North Atlanta High School. She had made the varsity cheerleading team. It was something she was very excited about. She had spent her freshman year on the JV team because she was also doing what's called all-star cheerleading or competitive cheerleading with the Stingrays in Marietta. One of the skills that she wanted when she tried out for varsity was she wanted to get her back tuck. Her older sister had been a cheerleader, and a lot of her older sister's friends were also cheerleaders, including her older sister's friend, Elena, who was cheering at Georgia State University. She had seen that Elena was posting about going to tumbling classes on her Instagram, and she messaged her and asked her if she could go with her because it was something that she wanted to get better at. And those classes were held at 800 Wendell Court, which is located in the city of Atlanta in Fulton County. It's actually unincorporated Atlanta. And that jurisdiction is the Fulton County Police Department and now South Fulton Police Department. So Michaela then goes to these classes. The gym is run not in a strict, structured way that I think Michaela was used to after being part of an all-star team, but it was kind of a pay-as-you-go whenever the classes are organized. They were typically Wednesdays in the evening hours between 6 and 9 p.m. She would go with Elena, and sometimes Elena would go with two other friends, Margaret and then her friend Minka, but Michaela only went with Margaret and Elena. It was during these tumbling classes that she was introduced to the defendant. Michaela will testify that this type of dynamic that she had with the coach was a little bit different than dynamics that she'd had with coaches before. He was relatively casual with her. The girls would talk about adult topics, men that they were dating as they were all in their 20s, relationships, concerns about their bodies, to which the defendant engaged Michaela in those conversations. They would schedule these classes and have group chat on Snapchat, which was also something that was a little unusual for this particular gym and this particular tumbling coach. Both Michaela and Elena will testify that they typically did not schedule tumbling classes or cheer time with coaches via Instagram or Snapchat. And that wasn't actually even how Elena found out about the gym. She found out about it through the gym's owner via text message. But Michaela will testify that she was in a group chat with the defendant on Snapchat, and that was their primary and only mode of communicating. Michaela will describe what Snapchat is to the court, how the messages can only appear for a certain amount of time, how videos and photos disappear. Because Michaela will testify that she had an individual Snapchat with the defendant. And Michaela will testify that they exchanged some pretty explicit messages on Snapchat. And Michaela will testify that she actively participated in these conversations. And that it was these conversations that made her feel special, that made her feel wanted, that made her feel desired by the defendant. And it was in these individual messages that the defendant elicited a nude photo from Michaela and also sent one of himself to Michaela. It was also in these messages that they hatched a plan to bring to fruition the sex acts that they had discussed. And Michaela's will provide some very graphic testimony about the sex acts that they discussed. Part of this plan is for Michaela to tell her mom that she would have a private one-on-one tumbling session with the defendant. That is a very normal occurrence in the cheerleading world, but it was the first and only time that she had a private lesson with the defendant. Michaela will testify that her mom dropped her off at the gym. It was June 7th of 2017. And that Michaela and defendant went about their normal business of stretching and practicing tumbling until the rest of the occupants at the gym left. So Michaela will say that there were some younger children there with another coach, and they were only there for about 20 to 30 minutes before she was left alone with the defendant in the gym. Michaela will testify that the power went out in the building and it was very, very dark, but that the defendant is the one who started the sexual encounter by kissing Michaela. Michaela will testify the defendant brought her over to a couch that was in the gym where he removed her shorts and performed oral sex on her. Michaela will testify that it made her uncomfortable at times. Michaela will testify the defendant after he performed oral sex on her, he then put his penis in her mouth and had her perform oral sex on him. Michaela will say the defendant held her head with his hands and almost forced her head onto his penis. Michaela will testify that the defendant ultimately ejaculates in her mouth and that she felt the taste of the semen, that it was gross, that it was salty, that it made her uncomfortable, and then she spit it out into a napkin that she was given by the defendant. Michaela will state that after the oral sex had finished, that she waited for the defendant with her mother, or for her mother to come pick her up. And that when her mother arrived, the defendant accepted a payment from the mother for the tumbling session. Michaela will testify that after this happened, she had disclosed to her friend Logan. Logan was her best friend, is still her best friend at North Atlanta High School. They were both on the varsity cheer team together. And that Michaela will tell you that she had told Logan about the relationship as it was building up, about her interest in the defendant, about the messages that were being sent, and that ultimately the sexual encounter took place. And Logan will testify that she was not as excited about the interaction as Michaela was, that she was actually a little upset about what Michaela had told her, and that she told Michaela that she needed to tell her mother and that what had happened was not right. Eventually, 2 days later, on June 9th, which was the day of her older sister's birthday party at Benihana, Michaela told her mom about what had happened. And Marcia Ward, Michaela's mom, will describe how that disclosure happened, where it happened, Michaela's demeanor when it happened, and Michaela's demeanor through the next night that Marcia actually captured in a photograph. Marcia will testify that she told Michaela that they would have to report it to the police, even though that wasn't what Michaela wanted to do, that Michaela did not want to get the defendant in trouble, that she just felt not right about what had happened, but she had no intention of ever having to talk about it again. And that she had no intention of getting anyone in trouble. Marcia will tell you that she went to the police, or she called the police and was told that she needed to come in and make a report, which she did the following day on June 10th. You'll hear the 911 call placed by Marcia Ward while she's standing in the Fulton County Police Precinct. And then an officer ultimately came out to her house, and she actually lives in the city of Atlanta. So it was about a 25-minute drive to her house. You will hear from that officer, Jimmy Sewell, who went out to the home, who will testify that he talked to Michaela in the presence of her mom, and that Michaela provided details consistent with what she had told her mom, what she had told Logan, and ultimately what she provides in her forensic interview and what she will testify to this court. Officer Sewell will tell you that it was his first sexual assault or sexual abuse call as a patrol officer, that he had no knowledge of what to do, which is why Michaela is now referred for what the state would deem a necessary forensic medical examination or a sexual assault nurse examination. The case is then passed off to Jamie Gore, who is the investigator at the time. Investigator Gore will testify that she had very little experience in handling these cases, but she knew that the first thing she had to do was schedule Michaela for a forensic interview, which she does at the Georgia Center for Child Advocacy. And that interview takes place in the latter part of June of 2017. Investigator Gore also assembles a lineup for Michaela to identify who the defendant is, and that she attempts to preserve the Snapchat messages, but was unsuccessful in doing so. Investigator Gore will also testify that she went out to the location of this gym, left her card, made several follow-up calls to see if she can get in contact with the owner of the gym, Miss Porter, but she was unsuccessful in that endeavor as well. The court will also hear from Dr. Wallace. Dr. Wallace is Michaela's therapist, and she actually had an appointment with Michaela on June 10th of 2017, which is the day after Michaela tells her mom, but the same day that Marcia Ward actually is able to make a police report with Fulton County Police Department. Dr. Wallace will testify that Michaela struggled with a lot of feelings of confusion and shame following the incident with the defendant, that she struggled with how to feel about it because Michaela identifies, and she will still identify, that she was an active and willing participant and that this was somehow her fault, even though she was not the adult in the room. Dr. Wallace will testify that that shame and confusion and anxiety over this didn't just exist on June 10th, 2017, when she initially talked to Michaela about it, but that it continued to persist into 2019 and even through today. Ms. Patrick, who is the forensic interview, will also identify some of that shame and confusion that Michaela provided to Dr. Wallace in her forensic interview. Ms. Patrick is a trained forensic interviewer, has testified multiple times as an expert witness in both the interviewing or conducting a forensic interview of a child, as well as disclosures of sexual abuse. Ms. Patrick will provide expert testimony as to the process of disclosure, the protocols utilized in a forensic interview, as well as how dynamics of sexual abuse impact a child's disclosure, specifically as it relates to grooming, coaching, and suggestibility. And the coaching piece will be a very prevalent part of Ms. Patrick's testimony, as it is a clear cut into what the state would call a textbook pattern of grooming between the defendant and Michaela Ward. The court will also hear from Dr. Tricia Sheridan. Now, Dr. Tricia Sheridan is an expert in the field of forensic nurse examinations and sane examinations. She's a doctor of nursing at Emory University School of Law, and also one of the individuals who works with grants across the country in helping hospitals properly staff and create sexual assault centers. Dr. Sheridan will provide some educational testimony on DNA, the lack of physical findings in sexual abuse case, and how the absence of physical findings is not determinative, and the reasons as to why that is. You'll also hear from Ms. Porter, who is the owner of the gym. Ms. Porter will testify that she didn't know Michaela Ward, that she had never interacted with her, that the appointments were not scheduled through her, and that the defendant was only loosely related to this gym, and he was not, in fact, employed as a full-time instructor or coach at her gym. The court will also hear from the defendant, in 2 recorded phone calls, admitting to having a private session with Michaela when he learns the identity of the child listed in the warrants, but also putting himself at the gym with the private session and attaching Michaela to Elena on the day that it happened, corroborating not only Michaela's testimony, the testimony of her mother, and also the testimony of Elena. He will admit in a second call that Michaela has no motivation and no reason to fabricate or lie about what happened. On the indictment, the defendant is charged in count 1 with enticing a child for indecent purposes. He is charged in count 1 for soliciting Michaela Ward to come to a specific location for the purposes of committing an immoral and indecent act with the child, with Michaela Ward. Now, enticing a child for indecent purposes can happen, requires the element of asportation. And you will hear testimony from Michaela that not only was she enticed to come to the location for the purposes of engaging the sexual acts, but that also that asportation, which is slight movement, occurred when she got to the gym and when she was moved to various locations within the gym to perform the various sexual acts. Count 2 is a count for aggravated child molestation, which is placing the accused's mouth on the sexual organ of Michaela Ward, a child under the age of 16. Count 3 is placing the accused sexual organ in the mouth of Michaela Ward, a child under the age of 16. And count 4 is for kissing Michaela Ward with the intent to arouse and satisfy the sexual desires of the accused or Michaela Ward. And count 5 is touching the genital area of Michaela Ward with the intent to arouse and satisfy the accused's sexual desires. At the close of all of the testimony and at the close of the state's argument, the state would request that this court find the defendant guilty on all 5 counts in the indictment. Thank you.
All right, Mr. Marks.
May it please the court, my client didn't do these things that the state is alleging that he did. Admittedly, and the evidence will show this, the defendant is, or was rather, the tumbling instructor at that location. We don't deny that. He was the tumbling instructor of the complainant in this particular case. We've got no issue with that. He was with Michaela on the very day and at the very time that she alleges that these things take place. He's not denying that either. He does not admit in the jail calls that he committed this crime. He doesn't know why. He doesn't understand what motive she has to lie, but he's not admitting to any of this when you listen to the jail calls. The evidence will show that there's absolutely no physical evidence corroborating any of this. There are no witnesses to this alleged event. There's no confession. There's no video surveillance footage or anything. The only thing that the state has, and the evidence will clearly show this, is the say-so of the alleged victim. And at the end of this trial, Your Honor, I'm going to ask you to find my client not guilty of all counts because my client, as he sits here today, is not guilty, and the state can't prove otherwise. Thank you.
All right, thank you, Mr. Marks. State may call us first witness.
Yes, Your Honor, the state calls Michaela Ward.
We invoke the rule of sequestration.